All right, so we're going to talk about estates, transfers, and titles in this one. So we're going to describe the various requirements for a valid deed. We're also going to identify the 4 fundamental types of deeds, their functions, and their warranties. Explain how property may be transferred through adverse possession and other involuntary means. We're also going to distinguish the transfers of title by will from transfers by intestate succession, and include the disposition of community and separate property in each. We'll also explain the necessity for recording legal documents, the difference between constructive and actual notice, and further identify the process for conducting a title search and the purpose of a title search. We'll further describe the origin of Texas land titles, the 2 evidences of title commonly used in Texas, and distinguish between lenders and owners' title policies, including covered and excluded risk, marketable title, and good and indefeasible title. Okay, so we got a lot to cover, but again, let me ask you all that have been here, does not all of that sound familiar from previous classes? Okay, pretty much that was all covered in law contracts, every single thing. So I'm just giving you a review, a refresher over what we already talked about. Okay, so this should not be difficult information. It's just a refresher for you. So a deed is the instrument that conveys property from a grantor to a grantee. Now, remember this, and this is very key, is when you go and transfer, if I want to sell you this pointer, okay, are you going to give me a deed when I give it to you?
No.
Am I going to give you a deed?
No, probably not.
No, so what am I going to give you if you give me cash and I give you the pointer?
The pointer.
The pointer and a receipt. Okay, so when you want to figure out what type of ownership is it, well, this is all you got to do. You just find out in this situation is if it is ever a transfer deed, if you're reading a question on the test and the test says that Travis gives Justin a deed, then what type of property is it? Real property, period. Okay, but if it says Miss Linda gives Justin a bill of sale, then what type of property is it? Personal. See how this is a refresher? Okay. So during the lifetime of the grantor, the deed basically says that as long as you have this, Mr. Eugene, you got the deed, you have it for the lifetime as long as you fulfill your duties. Okay. So, like we talked about in previous classes, remember the OR gives to the EE. Does that make sense? So whenever you see up here a grantor, the OR, they're the one that's conveying the property. They're the one that's giving it away. The one receiving it is a grantee. They're receiving, okay? Now, the requirements for a valid deed is that the grantor must have legal capacity to execute the deed. So does that mean, Mr. Eugene, that Stefan, who's 15 years old, can transfer you a deed? Why not? He's not. He's a minor, so he can't. Well, okay. Well, Aiden will transfer to you, but he's been mentally handicapped by a court. Can he transfer? Why not? Do you see where I'm coming from these? Okay. Well, Cody and you meet up at a bar, and Cody starts drinking and everything, and signs over his deed to his property to you. Is he able to give you transfer? Why not?
Both drinking.
Y'all are drinking. And what happens? He's what? He's incapacitated. He's intoxicated. Well, I'll give you, Travis went out and smoked a few joints, met up with you, and he wants to transfer your property to you, or his property to you. Can he end up doing that?
No.
Why not Travis?
Incapacitated too.
Because he's also incapacitated. That's the thing they're going to trick you on. They're going to say everybody's okay with mentally incompetent, minor, drunk, but when people throw illegal drug, okay, they think, well, in that situation it's okay. No. If he is mentally incapable of thinking right, he cannot contract. Does that make sense? So it doesn't matter what it's on, even if Travis is put on a mild sedative by his doctor. it can mess up his thinking and thus not allow him to have the legal capacity to execute that deed. Okay? Identifiable. Basically, you have to have the name grantee. So if Cody, you're giving Aiden your property, you have to state who you're giving it to. You can't just say, yeah, I give my property away. We have to have a designated person. Does that make sense? There also has to be, of course, consideration. We talked about that. There has to be consideration. And Aiden always told me it always has to be cash. Right, Aiden?
I was wrong. I told you that.
What's the truth?
Be anything you like.
Anything of what, though?
Value.
Value. That's the key thing. So anything of value. You can't give Mr. Eugene some garbage and say, hey, here's some consideration. Okay? It's got to be something that is of value. Mr. Eugene, look, Mr. Eugene, he's got some stuff for you. He's got some value for you. He's got chocolate chip cookies back there. So, he's coming. They'll trade their caps for the cookies. So again, there's consideration. There's also accurate legal description of the property. And today, Stefan, we actually had a surveyor come in. Is that important, really, this legal description? That don't matter about anything, does it?
It's very useful.
Why is it very useful?
It's how they identify the property.
And it's always 100% correct when they go out there and get on this. No? So it's very, very important we had that correct?
Yep.
Yes. Okay. They told us today in our meeting, they said on a survey, we can go out to a property and each four corners of this room, there can be a stake. And they can say, okay, well, there's the four corners. But the problem is the one next to it, the stakes are off. And because those stakes are off, the ones down there are off, and those are off. And so what does that mean about your property? It's off too. That's correct. So in those situations is you have to make certain that you give the accurate legal description so that the surveyor, engineer, and everybody can do their job to find and locate the property that you're dealing with. Okay. Again, when dealing with a valid deed, they must contain words of conveyance. And what does that mean? Well, say that.
So it's conveying
Exactly.
to so-and-so exchange.
Exactly. I so and so, and I, Justin, am transferring to Cody my property located at 123 Main Street. What have I just done? I have converted my property to you, and I have made it clear that that's my intent. Okay. It must be in writing and signed by a grantor or the agent. Now, Travis, say Mr. Jason wants to go over and you're his agent. Do you think it's a wise idea that you go put your John Hancock on his deeds?
No.
Why not?
I don't want to be involved in whatever.
Yeah, you don't want to be involved in that. Same thing like with, say, Mr. Eugene. You're his agent. He's like, all right, well, you just handle it all for me, man. I'll talk to you later. And he leaves. Well, what's the problem there? What if he's not all there? What if he's worked 16 hours and he's exhausted? He goes home, he goes to sleep. He already signed over his rights. He gets up. He's like, what the heck happened to my house? And then here he comes after you. Never, 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 unless your broker tells you different, never go over and transfer property in regards to or sign off on the property for the grantor. Now, Mr. Eugene, is it okay if Miss Linda is your power of attorney and signs off? Why is that? What about Elizabeth, Travis? Is it okay if she signs off on your stuff? Yeah, that's your spouse. Okay. But what about, say, Travis? No, sorry, Aiden. My bad. Aiden. What if you want Cody to sign off and Cody's not a licensed agent? Is that okay?
If I give him the power to.
If you give him power to, yeah. But Cody, do you want that hit or that liability? No. Okay. Just because you can get the power, is it always wise to take it? No. Okay. And then, of course, the last one, it has to be delivered to the grantee or an agent and be accepted. Okay. So, like we said before, we've had that discussion in here many times. Just because you sign it does not mean that it's been what? Fully executed. Okay. Now, the granting clause specifies the interest that is conveyed, either a fee simple or a life estate. Remember, there is a difference. how ownership is going to be held. Is it going to be in severalty or tenants in common? And it's also the type of deed is going to either grant, sell, and convey the warranty deed, or it remise, release, and quit claims through a quit claim deed. Okay, we're going to talk about that when we get to that section. In writing and be signed by the grantor, and delivery and acceptance can either be in person, through an escrow agent, which the date of delivery is usually the date the deed was deposited in escrow, or it's presumed if the deed is recorded by the county clerk. So when Mr. Eugene, you bought your house, did they, after you signed everything, the bank funded, then immediately the previous seller came over to your house immediately and handed it to you, right? The deed, they just walked over and said, here you go, Mr. Eugene. Is that how it worked?
Nope.
And what did they do? What happened, Miss Linda? After y'all signed and everything and the money was dispersed, who got the deed first?
The clerk.
The county clerk. Remember that priority?
It
Needs to get filed first, quickly. Because what happens if there's another debt on it, they take a junior lien. And they don't want to take a junior lien. So in that situation is the county clerk's the first to get it. You know, see how this works? Okay. Now, there also are reservations and exceptions. Now, this is pretty interesting. Say, for example, that as we go through these particular situations, we want to make certain that as we go through, we want to make sure that we do review all of these different situations. The subject to clauses, of course, are going to be very, very important. And what I mean about subject to clauses is this, is that the restrictions are going to be on the grantee's use. So coming back to this, and I'm picking on Travis a lot tonight, but I'm going to say this. So Travis goes over and you have some acreage, okay? So he has 100 acres and he wants to sell them off. He wants to develop them, okay? So Travis, you want to develop them. So he says, you know what? I don't want a bunch of old fogies moving into my area. So I'm going to sell them, but what I'm going to end up doing is I'm going to try to make them a student housing. Okay. Well, that's one way that he can set this. Now, can you put an age restriction where only 18 to 24s can move here?
Nope.
No. But can you end up developing the area to make it student housing purposed? Yes, you can. Now, could Mr. Eugene move into the area? Yes. But in the situation is, if he's older, do you think Mr. Eugene wants to move into a student housing area?
No, because he's old.
That's right. He's ancient, you know, his walker. But if y'all throw parties, his hearing aids are going out, so y'all should be okay. So,
I don't want to talk about. He's coming over. He's invited to all of them.
He's coming to all of them. Okay. Tonight, Cody, just let him know where the party starts, so he'll be there. So, but no, again, this is the restrictions can be placed by Travis on the grantees. Whoever purchases it, there can be restrictions. There also can be reservations. Travis may also say, shoot, I got 100 acres in Texas. I'm keeping the minerals. Okay. So he can keep the minerals. That can be a reservation. So it's retained by the grantor. And there also can be exceptions, which are rights that someone else has, such as mortgage liens, taxes, mineral leases, and easements. Okay. There's also a habendum and warranty clauses. Now, habendum is basically, it brings with what's called the to have an oath. So it matches the granting clause. And the granting clause basically rules is if there is discrepancy. So these defines ownership interest. Now, when we talk about warranty, there's different types, and we're going to talk about these. But it states the nature of the grantor's warranty. Now, if you give somebody, Mr. Eugene, if you sell your property to Stephan here, okay, Stephan wants and prefers to have this. He wants a general warranty deed. Because what it means is, Mr. Eugene, you're telling Stephan, this is literally what you're telling him. You're saying, Stephan, if you buy this property, I not only warrant that while I own the property, that it was good and clear, and I did nothing to encumber it, but also previous people that owned it before, I also warrant that they also did not encumber your property. So you're getting the highest and best forever usage. Do you see what I'm saying? So it's like, here you go, Cody. You want to buy this phone, and forever, I will always warrant this phone as long as you have it. Wouldn't that be nice if you could just forever, it's always taken care of? So it gives you the highest use. Now, in a special warranty deed, however, Mr. Eugene's telling you, Stefan, in this, that I only, Stefan, warrant for the time I had it. So if Cody had it before me and screwed something up, I'm not saying I justify for Cody. I'm just saying for my time, I did nothing to cause any issues on this property. Okay? Now, Stefan, how do you feel about that? You want to buy a property from him just for that one little period?
A little less.
Yeah, a little concerning there, isn't it? Okay. And the last one is a deed without warranty. And of course, no warranties, that's pretty much problematic. Okay. You're taking a risk in that one, and we'll talk about those in a minute. So an acknowledgement and or a jurant. And this is basically, neither is essential for the validity of a deed. Okay. Neither is essential to make certain that the deed is valid. It is required, though, for the recording. So while you do not have to actually notarize it, if you want it to be recorded, it has to have an acknowledgement or a jurant. And it's making it a valid conveyance against subsequent innocent purchasers. Okay? And the idea of the person signing has to be done by a notary public. So it basically is, the acknowledgement is going to say acknowledged before me, or if it's a jurant, it's going to say subscribed and sworn before me. And as a notary public, that's one thing that I have to do is, clients a lot of times, Cody comes in and he says, hey man, can you sign this for me? And I say, well, I need to see your driver's license. Well, I don't have it. Can't sign it. Why not? I have to show that you are that person, and I have to write information off your driver's license into my book. So because of these situations is, if I don't do that, then the entire thing is not valid. Do you see how that comes into? Okay. And a lot of people get very mad if you turn them down because they don't have a driver's license. Okay. A lot of them will, especially college students are bad with this. They'll bring me an expired driver's license. And I'm like, can't use it. Gotta make certain, because how do I not know, when they get an expired license, what do they do with it? They cut off the top of it. Okay. How do I not know that you don't have a twin, Aiden? You might have a twin. You stole your twin's driver's license. Don't know. So I have to have one that is active. Okay. Again, acknowledgement is a formal witness declaration. The person signing stood before a notary on a specific date, and acknowledged signature was his. The document may not have been signed before the notary and signed on the date it was notarized. So you cannot, Cody, you cannot go in, say that you want to sign this form here, Cody. You want to sign this form. So Cody comes over and he signs the form. And then he goes over to Mr. Aiden and he says, hey, I need you to notarize this. Aiden's going to tell you, I'm sorry, I can't, because I don't know if you actually signed that. And you're going to say, that's my signature. Sorry, I don't know if Stefan didn't forge it. I don't know what happened. So in that particular situation, you never sign a document that has to be notarized without the notary present. Does that make sense? Okay. A jurant is the formal witness declaration. So it's the document that's going to be signed in front of a notary, and the person is signing swears that the information, see the difference here, the information in the document is true and correct. Did you see that in this previous one? No. This one, we're just stating that Travis Stahl stood in front of me, and that is him, and he signed this piece of paper. That's all it is. I'm basically saying I saw him. Okay? This other one is Mr. Eugene brought me a document, and what he wrote up, everything in there is 100% true, and if he lied in it, then he ended up, he basically did perjury, and he can be in a lot of trouble for that. That's why if you ever go file stuff at the county clerk's office or the district clerk's office, there's a little thing most of them have on their plate that says, if you're filing something that is fraud or false or perjured, you can be criminally and civilly taken to jail. I mean, there's plenty of different things that can be involved. Don't mess with that. Now, what are these different types of deeds? Well, very, very important. Here are your 4 deeds you need to know. You're going to need to know these for your licensing exam. there is the general warranty deed, the special warranty deed, deed without a warranty, and a quitclaim. We're going to go through them. So the general warranty deed, like I already stated, Mr. Eugene, is what? It is the greatest protection of any deed. Greatest protection. So in that particular situation is, do you want a general warranty deed, Mr. Nobles, when you purchase a house? Why do you want that, Mr. Nobles?
Greatest protection.
Well, it provides you a lot of protection and a lot of times gives you warranties to take action if something's not done correctly. Is that correct? So when we're talking about these, it gives you the greatest protection of any deed, and implied warranties extend back to the origin of the title. Did you see that? The origin of the title means back from the very, very first time it was sold, we're going all the way back to that point. So it's the covenant, there's multiple covenants in regards to encumbrances, quiet enjoyment, further assurance, warranty, season. All of these are giving you different covenants that are allowing you to go back, and at any point, should there be any issues with this, they will remedy that matter. Does that make sense? Okay. Now, a covenant against an encumbrance, this deals with your special warranty. It warrants only the grantor's ownership for their particular term. So what does that mean now, Stephen? What exactly does it mean that it warrants only for that particular term? What does that mean to you, sir?
They don't know what happened before or after that term, right?
Well, are you going to take responsibility if Aiden owned the property before you? Do you want to have to be responsible for Aiden?
No.
Why not?
If he did something, it's on you.
Yeah, if he did something wrong, you're liable for it. Okay? So not something that we want to deal with. So if you notice back here, look at all these implied warranties. Do you see that over here? No. It only encumbrances the covenants against encumbrance. That's it. There's only one covenant. Look at this deed without warranty. This says no warranties, clear as day. And it implies the grantor simply has title and possession. That's it. So Miss Leela, she has a deed and her name's on it. She has a right to be in the property and she has the title, but she ain't guaranteeing anything else. Okay? She's not saying that I'm guaranteeing anything in the past. This is it. Okay? So you get no warranty, no coverage. And this is the best of the best. This is what we call a quitclaim deed. And it gives you no warranties, just like this one back here, but it also implies that there's no ownership. There's none. The transfers grantor's interest, if they happen to have any, and the only reason we have this is to cure a cloud on title. Okay? So in this particular situation, a deed without warranty is a basic deed. Okay? It's often sometimes referred to as what we call a bargain and sell deed, but a quitclaim deed is utilized in this particular situation. It's basically to make certain that as we go through these different situations, we want to make sure that if, for example, we can kind of put it this way, kind of breaks it down a little bit more. Say that that Aiden and Cody and Stephen, you're all brothers, okay? And your father, your last dad, he passes away. So your dad passed away, and at that point, you know, Aiden, you've been taking care of your dad's estate. You've always been there. Cody and Stephen, they ran off, you know, they moved off and went on, and they just forgot about their dad, okay? Well, when he passes, Aiden, you go over, and you end up in the situation, you say, you know what, I'm going to go in and sell the property to Miss Linda. She always liked the property, so I'm going to sell the property to Miss Linda, okay? But you don't consult with Cody or Stephen. You don't consult at all. You just go over there and sell the property to Miss Linda. Well, Travis, question for you. Can he do that? If their dad died and Aiden sells it to Miss Linda, without even telling Cody or Stephen, can he sell the property? No. That's the thing. If there was no will, then it's automatically deemed 1/3, 1/3, 1/3. So in that situation, Aiden, you, in that situation of selling, you actually didn't sell the property. You sold your 1/3 interest to Miss Linda. But how many interests are still out there? 2/3. We got 2 here. So when Miss Linda moves into the property, guess what happens? Miss Linda gets served with paperwork from Cody and Stefan that says you can't move into that property. That's our property and we didn't sign off. So title's going to be like, what the hell? Why didn't you tell us this, Aiden? Well, they left and they're never around anyway, so I thought they didn't want nothing out of the property. Is that your choice, though, Aiden, to make? No. So what happens is the title company is going to have to come to Mr. Cody and Mr. Grossman and say, okay, let's not try to cause a big issue. Miss Linda already wants it. Let us remediate or remedy this issue. And what can we do? And most of the time, what do people want? Do they want the property or do they want the money?
The money.
They want the money. So they're going to say, why don't we end up give y'all your portion in cash, and then we'll go after Aiden for anything that's left over. Okay? So in those situations is they will basically, if everybody comes to an agreement, they'll do a quit claim. So Mr. Cody and Mr. Stefan, y'all would sign a quit claim, and that would then be filed, and that would cover that now gap on title. Does that make sense? Now, you ready for the problematic situation, though? I've had this before. Had a client that was wanting to sell their property. Was about to put it on the market until I found out that one of the children told or contacted me and said that, no, you're not selling this property. There's other children involved in this. And I said, what do you mean? Well, this husband and wife, the wife had passed away, the husband was still alive, the husband died, and the person I've been dealing with was one of the daughters. Come to find out that there were 12 children total from that marriage. And of those 12 children, 2 had 6 children each, and both of them had died. So, guess what happens in that situation? You got to get every one of those people to sign off on the property. Think that's fun? Not at all. Not at all. Okay? And just imagine, and this was the situation, they were all over the United States. So after you get one to sign, you may have to take that form and send it off to another, 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 and they're all over the place. And now, Cody, what happens if one of them, just one, refuses to sign? Then everything stops. Mr. Eugene and Miss Linda can tell you they've been there before. My dad had put a contract in on a property. They were buying some land, and ended up there was a ton of children, and one of them refused to sign. And if they refuse to sign, there's no transfer. That thing sits. Okay? So again, that's one of the things you need to be aware of. Now again, in a deed in trust, now a deed of trust, that is what's going to convey the real estate to a trustee, and it's a general warranty or special warranty deed. Okay? A trustee's deed is going to convey the real estate from a trustee, and this is oftentimes going to be what's called a special warranty deed. There's also the deed pursuant to a court order. There can be an executor's deed, a sheriff's deed. Usually these are special warranty because they're only for a short period of time, and there is full consideration that's going to be stated. So again, this kind of breaks down the item in regards to what's called a deed in trust or a trustee's deed. The deed in trust, as you see at the top here, is you have the trustor and the trustee. They're going to be the deed in trust, and this is where the reconveyance occurs, okay, where it can end up going back to the trustor. Or if you're going to have a full-blown trustee's deed, you're going to have a beneficiary that's going to be involved. So it kind of shows you, if you follow those arrows, it kind of shows you the path of how this basically goes. So the trustor is going to end up giving it to the trustee, but if the trustee is not paid off in full, what happens? Then the deed goes to the beneficiary. But if the trustor pays off the deed, then it reconveys back over to the trustor. You see how this works? Now, we're getting into some good stuff now. So I've kind of bored y'all enough. Now I'm getting some good stuff that y'all are ready for. What is involuntary alienation? Put it simple. You ready? Here we go. It's involuntary alienation. I like this.
Let's say if somebody leaves someone else and they weren't expecting it.
Well, you can't see me here, but I'm over here. I'm over here, Miss Leela. I'm helping myself to some laptops and some AirPods. You want some stuff too?
Yeah, sure.
Okay. Let's see. Well, here's another. Let's take that one too.
We'll get it back at the party.
There's nothing up here.
But in this situation, here's what it is. The situation is, guys and gals, is it? What did I just do, Cody, to you?
Just came in.
I just took your crap. Yeah. I just walked over there and just said, yeah, this is mine. How many of y'all, it's kind of like,
No, we don't have
let's
anything.
see. I like this phone,
Nothing.
and I like these I'll take these. What else you got? You got some car keys? Miss Leela, you want a car?
I sure do.
Without the car payment.
Yeah, without the car payment.
I mean, Justin's got 4 of them.
No, I just take the car. Thank you, Alex.
So when we're coming into these situations, the key thing that comes into it is involuntary alienation. Is what's involuntary? What's that mean? I'm just going over there. I'm just taking it without your consent. Okay, I just walked over, took your crap, and walked off with it. Okay. So involuntary alienation is it's transferred without the owner's consent. Okay. It's one of the basic one is what we call like escheat, impotent domain, erosion. These are the ones that we've already talked about before, but it's the simple thing of doing what? I'm coming to just take your stuff. I'm just going to take it. Okay, I'm not going to ask your consent. I'm just going to come take it. All right? Now, of course, we know that tax and mortgage foreclosure is, of course, going to be the most known one, but also adverse possession. There actually, I meant to record it and plug it in here, but I got behind. But there was an article, a gentleman that ended up, actually, let me sit down for a minute. Let me see if I can't still find that one. If I can, I want to show y'all this because it's upset a lot of people right now. Let me see here. Let me see if I can't find it. Let's see here. All right, so here you go. Here is the video. Listen to this real quick, everybody. I can't get it to play. There we go.
Flower Mound's Waterford Drive is lined with well-manicured $300,000 homes.
Look at this.
So when a new neighbor moved in without the usual sale, mortgage-paying homeowners had a few questions.
What paperwork is it and how is it legally binding if he doesn't legally own the house? He just squats there.
Lee Lowry and her husband told me the house down the street was in foreclosure for more than a year. The owner walked away, then the mortgage company went out of business. Apparently, that opened the door for someone to take advantage of the situation. Kenneth Robinson told us he's no squatter. He says he moved in on June 17th after months of research about a Texas law called adverse possession.
This is not a normal process, but it's not a process that's not normal. It's just not normal.
Robinson says this piece of paper gives him rights to the house. It's an online form he printed out and filed at the Denton County Courthouse for $16. It says the house was abandoned and he's claiming ownership.
I went through, look at it, and added some things here, for my own protection.
The house is virtually empty, just a few pieces of furniture, no running water or electricity. But Robinson says just by setting up camp in the living room, Texas law gives him exclusive negotiating rights with the original owner. If the owner wants him out, he would have to pay off his massive mortgage debt, and the bank would have to file a complicated lawsuit. Robinson believes neither is likely. So if he stays in the house, after 3 years, he can ask the court for the title. That's your goal eventually, is to have title of this home, to be the owner of this house.
Absolutely.
And
On the record, at this point, since I possess it, I am.
Robinson posted no trespassing signs after neighbors asked police to arrest him for breaking in. The Flower Mound officers say they can't remove him from the property because home ownership is a civil matter, not criminal. Lowry and her neighbors continue to look for legal ways to get him out.
Or if he wants the house, buy the house like everyone else had to. Get the money, buy the house.
Robinson says he's not buying anything. As far as he's concerned, the $330,000 home is already his, and he has the paperwork to prove it. Casey Norton, Channel 8 News.
So that right there shows you, and like I said, I wanted to show you all that video because of the fact of the matter is, guys and gals, that is what adverse possession is. Adverse possession is where you end up, if a person leaves their property, if they end up and they leave and the bank themselves go out of business, the laws of Texas is that we do not want properties to be vacant. Because what does it do? What if that house had never been possessed? Say that they just let it sit there. What's going to happen to the values of that neighborhood? It's going to drop because over time, if nobody takes care of that house, your values are just going to drop. Okay. Now I will say how they're probably going to try to get him out. It's most likely if it's in a $300,000 or $400,000 neighborhood, it's probably in an HOA. Okay. And if he's the owner of said property, he's got to pay what? HOA dues and maintain it and keep the property up to par. And if he doesn't do that, then what did we talk about before? They can sell the property and end up get their money and put it up for sale at that point. Okay. Yes, this is very recent, as I believe last week or the week before. So this just happened. So, yes, Ms. Lynn.
I know my brother talks about that very frequently around Itasca, Hillsborough,
Hillsborough and all that.
and in that area. That's
Because
not uncommon.
What happens is a lot of times, guys and gals, a lot of people get into the mortgage business and the banks they go bankrupt. And if the bank goes bankrupt or not bought out, then pretty much there's not much that can happen. Now, does that happen a lot? No. But can it happen? Yes. Now, the only thing is that if you do something like that, do you think you're going to have pretty much friendly neighbors?
Oh, no.
Not at all.
Probably not.
Not at all.
They're gonna hit you.
Especially when they find out that you ended up, he paid $16 for a $300,000 house. That's a steal. Okay. So all of my agents tomorrow, your job is to find me some of these so I can buy me some houses for $16. That sound good?
Can I ask you a question?
Of course.
He bought that house for $16,
Uh-huh.
and these other people's houses are worth 300 plus,
Uh-huh.
9%.
Mhm.
So wouldn't that mean, what does that mean for the other people's property? Wouldn't that bring
Nope.
down?
Because it's not like it's on the MLS as like
Yes,
sold
yeah.
for
It wasn't
$6,000.
sold.
Okay.
It's
all
just,
right.
so he doesn't really, while he quote unquote owns it, he's still in the situation while he quote unquote owns it, he still has to stay there for 3 years.
Right.
And he has to maintain ownership of the property for that time frame. Now, here's some other little ways that comes into it. He has to pay the taxes on it for 3 years. What happens if Travis goes in today and pays the taxes for this year? Did he pay the taxes for 3 years? No. What happened? He just screwed up that guy's whole plan, and guess what? He's got to recalculate everything. There are methods to end up in regards to how you can basically screw up the whole transaction. That's why I tell people be very careful. But you can't be like that woman was really mad. You can't really be mad at the guy if he found a legal loophole. I mean, there are people that are out there that was in Houston back in 2008 when the market crashed. People were buying houses for $300 at tax sales. $300. So why be mad at the guy just because he used the right thing? You know, and I tell those people this all the time is the information's out there. You just got to get out there and look for it. You see what I'm saying? Okay. So again, in regards to involuntary alienation, again, you can kind of see the very first one they're talking about is regards to the person dies intestate, which means there's no heirs. That's the key thing. There's no heirs. So if you leave heirs, you can be intestate, but it's still going to go down to your next of kin, if that makes sense. So we're talking about if Cody dies and you have no family, no nobody, then everything in that situation is it's called escheat, and your stuff goes to the state. Okay, but you got to have no heirs. Now, if the land is needed for public use, then we use what's called eminent domain through condemnation suit and payment of just compensation, and the property is taken by the public or a government agency. Then there's the non-payment of debt secured by real property, mortgage not being paid. You're going to be foreclosed on, and it's going to go to the creditor. if it is, and this is key here, this is the one we just talked about, the bottom one. If it is open, notorious, continuous, hostile, and adverse use of another person's property for a prescriptive period, that is called adverse possession, and it would go to the adverse possessor. Okay, so in this situation is that if I go in, and it doesn't have to be simply because of non-payment of a mortgage. I could literally say that Miss Leela has a house that's in Houston, okay? And she lives in Dallas. Well, her main residence is in Dallas, and she has a home in Houston. Travis decides, I know she's out of town, and there's been COVID and all this ice storms and all. She's not going to be down here, so Travis goes on and moves into the property. And he, open and notorious, continuous and hostile, lives in that property. But guess what? Does Miss Leland know that he's in the property? No, she's in Dallas. So she's in Dallas, he's living in the property, and then she starts seeing that her taxes are paid. Well, sometimes if somebody pays her taxes, some people may just say, well, heck yeah, I've got 3 taxes. You know, no taxes, so she ignores it. Second year comes around, same thing, taxes are paid. Third year comes around, same thing. Next thing she finds out, guess what happens? She lost her property. Okay? The reason behind this is we don't want people being able to just buy up property and it just sits. You see what I'm saying? We want people being able to live in that property. The same concept as this. There are plenty of times, especially Miss Linda and Mr. Eugene and Miss Leila and Mr. Jacob and all y'all probably know, there are people back in, you know, probably earlier time in the 80s, 60s, 70s, any of those times, a lot of times your families owned a lot of property, okay? Sometimes hundreds of acres, if not thousands, okay? Well, if they own thousands of acres, say, Aiden, that your parents own thousands of acres, are they going to know that Cody moved in at the very back part of that property and just sit there and built up a camp and started building a house? Are they going to know that stuff? No, because they're going to stay where? At the front part of the property where the house is. So the only way they're going to find out about that is what? Is if they happen to just go out there and see. But back in the 1960s and 70s and 80s, did you really go driving RVs and all, or not RV, RTVs, ATV, whatever they are? Did y'all drive those around? No, they didn't have them. Okay, so most of the time, people would end up, they would just set up shop and end up, they would be living on your property right underneath your nose, and you not even know. Okay, how many of y'all's parents still have a lot of land? Anybody in here? No? Kinda?
Not parents, but family.
Family?
Family.
So if your family has that kind of stuff, it ends up, it's a lot of land, there's still a lot. And especially, what if they're older? That's hard for them to take care of that stuff, okay? And I can tell you, I worked in Huntsville, and when I worked for a law firm, it was my last class, or my last case that we worked on was an adverse possession case. This little old lady, black lady, sweet as can be, loved her to death. She was helping this older white gentleman. Always been helping and all that kind of stuff. Well, he died. Well, when he died, his children were gone. So she'd been living at that property for 28 years after he died. Nobody said anything. She didn't say nothing. She wasn't very well educated, so she didn't know what to do. She just continued to live there. Well, she was getting frail. She's getting older, and her children came into our law firm and said, you know, we would like to file adverse possession, and we would like to take possession of that property. And, you know, and I never knew nothing about this until the attorneys talked to her and all and told her what to do. And she went ahead and did the stuff, and she got the property. And right after everything was done, guess who showed back up after 28 years?
Her family, his family.
His grandchildren.
Uh-oh.
And said, no, get out of the property. This is our land, get out. And guess what the judge said? You did not use reasonable time to come in and fix it. 28 years is not reasonable time. So you can't just come back in here, and number one, you're not the children, you're the grandchildren. So, no, you're not going to get it. And when I left that law firm and all, she actually did it. Her family got the land. It was probably 10 acres. It wasn't a ton. But still, 10 acres of land, that's not a bad deal. Okay? So, again, that's one of the things that comes back to is it's your responsibility. If you buy something, you got to maintain it. If you can't maintain it, then you don't need it. Okay?
I have a question.
Yes, ma'am.
What year was that when you when that occurred? What year was that?
Oh, gosh, Miss Lila, that's probably at least 2004, 2005.
Okay.
Why, you know somebody that happened to?
No, the storyline sounds intriguing.
It was.
And so I was just.
It was funny because I was going through my paralegal program at that time, and it was about 2000. I would say 2005, maybe six, either 4 or 5 or 6, somewhere in there is when I did it. It was the early 2000s is when it happened, and I still wish I had that lady's name. I wish I still had all this stuff because I wish I could bring that in here and show y'all because it's open records. All that is open. But you can actually Google a lot of times. If you just go to the courthouse, you can ask how many adverse possession claims are filed, and they can give that to you. That's open records. So if you ever wanted to know, you can pull it and see. But it's a good, like I said, it's a good thing that happens, and a lot of times people get mad about it. But I'm sorry, why are you getting mad about it when you couldn't pay your mortgage? You know what I'm saying? Why are you getting mad if you're a neighbor? I mean, the guy used a great idea. The lady used a great idea. That's perfect. They used what they were supposed to. You didn't do your job? Sorry. I mean, that's how I look at it in the situation. But again, you're going to see a lot more, and I guarantee you, every time there's a drop in the economy, you see adverse possession claims skyrocket. Okay? Now, you want to get the best deal for all of you, go to tax sales. Because here's the thing. If you make it adamant that you go to tax sale after tax sale after tax sale after tax sale after tax sale, guess what ends up happening? You're going to one day be there on the right time at the right moment, and you're going to be able to get a property very, very cheap. Okay? But you got to be there. Does that make sense? Okay? So again, adverse possession, it clears up boundary and dispute, title disputes. Owner who does not use or inspect land may lose title to adverse possession. And the possession of adverse claimant must be, again, like we said, open, notorious, hostile, and uninterrupted. That's where that guy's going to have to be very, very key, is that he's got to make certain it's not interrupted. Because if it's interrupted, it can screw up what he's trying to do. If you notice, that's why he's got all the stuff in the house. He's trying to keep hold, got the no trespassing. Okay. Now, tagging permits, combining successive ownership periods are also going to be some of those that you need to be aware of. Now, there is the 3-year statute, as he stated on that video. It requires a chain of title and possession under a general or special warranty deed. There is also the 5-year statute, which requires tax payment and use of land and must have, of course, another recorded deed. There further is a 10-year statute that requires adverse possession statute, requires use of the land. However, there is no deed requirement and no payment of taxes that have to be required. But why are we going longer in time? Well, we want to make certain that no family comes back and tries to collect, okay? Because Mr. Eugene and Miss Linda, if you come around at tax time and your taxes are paid, what are you going to end up thinking, Miss Linda? If you come to tax time, you've been saving up, and you get in to pay your taxes, and Aiden's the tax person and says, Miss Linda, your taxes have already been paid, ma'am. Are you going to say, okay, wonderful, goodbye, walk away?
No, I'm going to say there's a problem.
You're going to say there's a problem. Why are you going to say that? He just told you you don't owe no taxes.
Go buy yourself a
No.
car.
Go buy yourself a car, Miss Linda.
Nope,
Why not?
because I know that there's taxes due at the end of the year.
So you're going to inquire.
That's right.
That's the same thing. That's why they always say there is no free lunch. Okay? If somebody ever says something's been paid, you need to inquire. Right? Except for today, right? So in that situation is you got to make certain that you look at this. There's also the 25-year statute, which requires a recorded deed, even if it's void, and an absolute bar against claims to any other. Okay, so as you can see, there's multiple statutes. Now, Travis, should you go out as a real estate agent and start telling all your clients, well, don't buy that house, just go move in? How's that sound?
That sounds great.
Sounds great, right?
Do it, right?
Let's make it. Just move on in there. Yeah, you want to get your client shot? go do that. Okay. The key thing that you want to do is number one, you got to make certain that you know the full story. And I guarantee you, that guy that I just showed you, I guarantee you he's not some dumb guy. I guarantee you he's had legal counseling. He has researched that house. He has probably Q&A'd all the neighbors around the place to find out the whole story. He's done his due diligence, and he got lucky. Okay? And that happens. Now, does it guarantee him, Mr. Eugene, that he'll get the house?
Not really, no.
No, it's a 50-50 shot. And I'm going to tell you something else. If you do, and this is something I tell my people every time, every semester, if you're going to deal with adverse possession, understand that while adverse possession is a civil matter, if I go in and I break into Travis's house, what have I done, Mr. Travis, if you're still living there? I have trespassed on his property. Now, is that a criminal matter?
Yep.
Yes. So in that situation, you don't tell your clients to go busting in a door and all that kind of stuff. You end up, you have to make certain that if they want to do adverse possession, they need to seek legal counsel. And that is not you. Okay? You can tell your clients about what adverse possession is, but don't you dare tell them to act. And my personal opinion is you don't tell them even about adverse possession. If you see a property that might meet adverse possession, you may want to recommend they go speak to counsel, but don't try to explain it to them. Because I guarantee you this is what your client's going to hear. When you tell Mr. Eugene that, oh yeah, Mr. Eugene, yeah, if you live there for 3 years and and then you can get the title, but you need to seek legal counsel. This is what Mr. Eugene heard. I need to break in and live there for 3 years.
Yeah, I'm gonna do that. Free house.
That's what he heard. That's all he heard from me.
Somebody
Okay.
says, he told me I can do that.
That's exactly what's going to happen. And when he gets arrested, he's going to say, it was Aiden. Aiden told me. It's all Aiden. Okay? So in that situation, you've got to make certain that you do not share that. You just simply say, Mr. Eugene, I think you should go talk to an attorney about adverse possession. And leave it at that. Okay? If he started asking, Mr. Eugene, I think it would just be best advice that you go talk to an attorney about adverse possession. And let an attorney explain that to Mr. Eugene. Because otherwise, Mr. Eugene is simply going to hear free house, move in 3 years, and if something goes wrong, it's all Aiden's fault.
Right.
That's what he heard. Okay? So I'm just fair warning you. Now, that's finishing with adverse possession. Now we're moving into transfer of property based off of a deceased person. So you can transfer property by will. So Miss Linda, you can, when you pass away, you could transfer your items, your possessions to your children, and that is done by using a will. And that is voluntarily done because the owner voluntarily conveys that property after their death. There is a formal or witnessed will is the most normal, but sometimes there can be a holographic will, which is basically a video recording. Some people on their deathbed, Miss Linda may be on her deathbed, and she says, Eugene, go get the camera. All right, put the deal up, record me. And so he's got you recording, and she says, I want all of the stuff to go to Travis. All my things, I want it to go to Travis. Okay? And so then, guess what? Now in that situation, what is the last will of record? A holographic will. Now, what if, however, Mr. Eugene, he touched, you can't get out of the house.
That record ain't gonna get the court.
So
I didn't delete that.
he doesn't. But so went over there, that situation, well, you may have the will, but guess what? We now have this holographic recording. Well, now what has to happen, you got to kind of look at it, because the thing is you got to say these exact words. I revoke all previous wills. And a lot of people forget that. They'll just say, I give all my stuff to Travis.
I didn't do that.
Okay. Well, if he does, or if she says that, did she revoke her previous will?
Nope.
No. So now court has to do what?
Decide.
They got to decide, was she in her right mind when she recorded that? Because we talked about legal capacity.
They probably say I was not in my right mind.
Travis is going to say you were.
You were, yeah, you're pretty fine.
I believe that.
Yeah.
She tied herself to that chair.
So again, those are your different ways, but again, it's voluntary. Now, intestate, of course, is the basics of no will. Okay, so if a person dies intestate, there's no will, period. And then, of course, there is a transfer on death deed, and we'll talk about that later on. Now, what are the requirements, though, for a will? Well, of course, we got to be of legal age, all right? So, Miss Linda, if you're creating a will, you have to be of legal age. You can't be 15 and create a will. You have to be at least 18 years of age, okay? Or whatever your state classifies as legal age, okay? You have to be of sound mind, okay? You have to actually be of sound mind when you do this. There also has to be proper wording. That's why I said earlier about the revoking part. You don't put it in there, it leaves it subject to who? The court to interpret, okay? There needs to be no undue influence. So Cody can't come over and put Aiden in a headlock and say, sign that deal that everything goes to me, okay? That's undue influence, can't do that, okay? And it has to be signed and it has to be witnessed, but it's not required on a holographic will because you can't really witness that all the time. And if there's going to be a change to that will, you use what's called a codicil, okay? Now here's the thing. And I'm telling you all this. A lot of people do this. Stephen decides, I'm a poor white guy that has no money. Okay? And so, but I want a will because I want to leave whatever I do have to Mr. Cody. Okay? So if you are a poor guy, doesn't matter what race or whatever, you're just a poor guy. Okay? Do you end up, are you going to go hire an attorney to draft your will? No, it doesn't matter what it is. You're poor. You don't have the money to go hire an attorney. So what's he going to do, Miss Linda? If he's a poor guy, has no money, what's he going to do? It's not handwrite. What do we have nowadays?
He's gonna go on the internet and go.
He's going to go on the internet, Google wheel, and he's going to type some crap out. Okay? But did we not talk about proper wording? Do you think he's going to use proper wording? No. So he's going to type some crap out, and he's going to call this his will. Can it be his will? Yes.
It can.
Yeah. Even a will that's handwritten is a will. Okay? But here's what happens. He gets mad at Cody one day. He says, screw you, Cody. I don't like you anymore anyway. I like Aiden better. Aiden's a lot better. So he goes, gets another one, and he writes out that Aiden gets everything. Then next thing you know, he gets mad at Aiden. So he says, I don't like either of y'all anyway. I like Travis. Travis is the best ever. I'm giving everything I got to Travis. So he writes it out. Gives it to Travis. And finally, Stephen dies. Now, what's the problem, Miss Linda? How many wills does he have out there? 3. Did he revoke any of those wills? No, he just drafted a will for everyone. Which one takes precedent? Most of the time, the first. So it really comes up to a judge that now has to decide. Because while you're going to say the first, what's Aiden going to say? Second. What's Travis going to say? Third. So in that situation now it's got to go to a court. Okay? So again, it's very, very important that you understand that when you're making wills, you don't just do these willy-nilly. This is very important stuff, okay? And Mr. Eugene, is it wise that you only do one will in your entire life? What's going on right now with your situation? It's a mess, isn't it? When you do one will, it ends up, not all that stuff is in there. Guys and gals, I used to work with a probate attorney, and I can tell you from experience, a person would bring in a will. It was made when the parties just got married. The husband and wife just got married. and they lived for over 50 some odd years past that. But do you think 50 years, do you think things change? Yeah. Even in 1 year, things change. Okay? And when we got the will, all the people that were supposed to be executors were dead. And the children that were supposed to get it, 2 of them had died. What's the problem? Now you got to figure out who gets what. What was the intent? And God forbid if they were Stephen and didn't have no money, do you think they did all of the intent stuff of where it's supposed to go and go and do? No. So now who gets to make the decision of your will? Some third-party judge. Okay. Now, of course, a lot of people simply think this. Well, as soon as I go over here and, I've created a will, we don't need no will. We can just, my aunt did this. Oh, Eugene, we don't need no will. We'll just go out there and take what we want. And then we'll just sell the properties, and then we'll just transfer the money. We don't need no will or any of that crap. Well, what did she find out that had to happen? She's got to go through what, Mr. Eugene? She's got to probate that stuff. You can't just go out there and take it. Okay? So in that situation it has to determine the validity of the will. This is where, Mr. Eugene, you may say, hey, I have another will over here. This was my mom's will. And your sister may say, no, this is her will. And then Travis may come in and say, no, both y'all wrong. I had the last will. Okay?
Look, I recorded it.
Yeah, he got it on record. He can recorded it. Okay?
I get all the stuff.
He gets everything except the debt. The debt y'all can have. That's the only thing. Except debt goes to y'all. Okay?
It goes to your sister.
So it establishes the assets of the descendant, and then it, of course, establishes who the heirs are. Okay. Now, of course, it's conducted in the county where the deceased lived. Now, Mr. Eugene, in your situation, where did your mother live?
Hampstead.
But where does she really live?
Brian with her daughter.
She lived in Bryan 90% of the time.
Yeah.
But the question comes back when we talk about lived, we're talking about where is their home? Where is their main source? Where do they live at? Okay. You can live anywhere, but you end up, where do you call home? Okay. So in that situation, while she lived here most of the time, her property was in Waller County. Okay. So it's conducted in the county where the deceased lived. Now, if there's no fixed residence in Texas, then it's the county the principal estate was located or the county where they died. Okay. And it must occur within 4 years or the property passes by descent. So, Mr. Eugene, if they don't complete the probate within 4 years, then it automatically transfers by descent. Okay. Now, the terminology that we use is going to be intestate. Like we said, it dies without a will. Testate means that you died with a will. Testator is a person who makes the will. And administrator, and you see this X at the end, administratrix, or executor, or executrix. These are, the OR is the male version. The RIX is the female. So, Miss Linda, what would you be called if you're an executor?
Executrix.
Yes.
Say that again, Miss Linda.
Executrix.
Mr. Travis, if a court appointed you to oversee Cody's will, then what are you called? An administrator. So what about Mr. Aiden? What would Miss Leela be called if you chose for her to establish and handle your estate? What would she be called? No, sir. Executrix.
Oh, okay.
Because here's the difference. Administrator is appointed by the court. The executor or executrix is by the person that created the will. So here's the easiest way to remember it. If you wrote a will and you appoint somebody to manage your estate, it's going to be one of these two at the bottom, executor or executrix. If you have no will or did not appoint somebody, it's going to be administrator or an administratrix. Does that make sense? Now, in regards to terminology, The device, which is going to be to gift of real property by will. Devisee is the person receiving the property. Remember that EE, receiving. The bequest or legacy is going to be the gift of personal property by will. And the legatee is going to be the person receiving the personal property. The descendant left no will. If they're intestate, then there's no will. The process in this situation is that there is going to be the court will appoint an administrator. Okay, so if they have no will, court appoints an administrator. The community property is like it says. Community property is the spouse of the deceased already owns his or her half. All surviving children and descendants are going to be in common to both spouses, and they all to the surviving spouse. So in this situation is, in a community property state, which we are here in Texas, the spouse of the deceased already has their half. If all surviving children and descendants are in common to both, meaning that your parents never were broken up, they've always been your parents, if the wife dies, the husband automatically gets everything. But if they are not in common, the children and descendants are not in common, then the spouse only gets half, and then the other half goes to the children. Does that make sense? Okay. Now, if it is separate property, the surviving spouse and children, there's going to be 1/3 of the real estate to the spouse, and this could be a life estate, and it's balanced out the remainder to the children. If the children, but no surviving spouse, then of course shared among the children. And if the surviving spouse, but no children or their descendants, then half of the real estate would go to the surviving spouse, while the balance would go to the parents or one parent or their brothers and sisters. The goal of this is we want to try to keep the things what? Amongst family. Okay. The transfer of title on deed death. Again, the transfer of real property interest during the lifetime. The transfers to the beneficiaries on death without going through probate, and it must be recorded before the death of the transferor. It can be revoked at any time by filing a new TOD or a document expressing to revoke it. A divorce between the transferor or a beneficiary will automatically revoke a TOD if the divorce is recorded before the death of the transferor. Again, TOD will be voided if the transferor is going to convey the property to someone else before the transferor dies, and the deed is recorded before the transferor's death. If a person really wants to cause problems within their family, the best thing they can do is on their deathbed do a video will, and say, I want to change everything up that I just did. And then I die. Because now guess what happened? You just caused probably a good couple of years of fighting over the money. Okay? Again, this kind of gives you just a chart. I'm not going to go through these. This just kind of gives you a chart in regards to a product given by and who it's received by. Y'all can read through that later. I want to jump on in here into our public records. Okay? When dealing with recording, okay, they are placing documents in the public record in the county where the property is located. Okay, so it's where the county of the documents are going to be located. It gives legal public constructive notice, and it establishes the priority of most claims. Okay, so in this situation is when it is established, it establishes the priority of most claims. Okay, now it also is not required for the deed validity. So because there is no effect against the claims of subsequent innocent purchasers if it is not going to be recorded. Again, it's very important that you do go through in these particular situations and that you are making certain that as you go through these, that we are filing things so that it ends up, it brings into some of us a notice that if you want to find out who owns the property, you can go down to the title or to the deed record and see who has it. We can also find out, is there a debt on it? Is there any other things in that particular situation? You can find it all through the recording. Now, to be eligible for recording, it's got to contain an acknowledgement or jurant. We've already spoke about that. It's acknowledgeable for a notary. It could have been signed previously, which is acknowledged, But if it's signed and sworn to before a notary, that's going to be a jurant. Okay. Now, paper documents must have original signatures or be attached to a document with original signatures acknowledged or sworn to with a jurant. The eligibility for recordings is it must be in English. I have people that ask me that all the time. Can it be in Spanish? No, it has to be in English. That's the law. Is any documents filed has to be in English unless it meets one of the few exceptions. Okay. It also contains a confidentiality notice that if the social security numbers are in there and the driver's license, they may be removed. So when you're filing something and it has the social security numbers or driver's license numbers, in that particular situation it can be removed for confidentiality purposes. I will tell you, a lot of divorce decrees, people don't catch this. When they file divorce decrees, their social security numbers and driver's license are sometimes in those decrees. And they don't even know. Okay? So you want to make certain, because what happens? If there's an identity theft, what can they do? They simply go down and find Travis Stahl. Oh, there's his social, there's his address, there's all his information. I got it all right here. Thank you, Travis. And they go become Travis Stahl. Okay? So be very careful. So it is in regards to the eligibility for recording. It is the effective as of September 1st, 2007, that a deed or deed of trust no longer can include a social security number. But if it does, the county clerk still has to accept it. Used to you had to, but not anymore. It will include the address for document return and will be reported, but with a penalty. Again, electronic filing, there's a lot of things nowadays that are going the electronic method. Electronic documents are going to be a document in the electronic form that satisfies the requirements. An original on paper in writing, signed, witness, or acknowledgement. Okay. The key thing, I'll explain something. The minute, Travis, if you sign a deed, you sign it physically, it is still paper. But the minute you scan it in and you file it, now the UETA and all the other electronic laws now come into play. Does that make sense? The county clerk, of course, may receive, index, store, archive, and transmit electronic documents. They may provide access to documents and information by electronic means. An original signature is not required on a document electronically submitted, though, okay? Because you can't really sign an electronic document by pen and paper. In regards to notice, constructive notice is that all persons are charged with knowing when they are going to have recorded instruments, as well as possession of the property. Again, we've had this discussion before. Electronic or constructive notice is, I actually go file it at the courthouse. Because I filed it at the courthouse, can any of y'all find that information? Yeah. Now, Travis, can they give you hell on getting it? Yeah. His grandpa, poor grandpa's going through that right now. But in that situation is they have to make it available. So you're under what's called constructive notice. Actual notice is what? You actually have walked up to Cody and said, here you go, you've been served. You see what I'm saying? Okay. The title search. Why in the world is title search such a big situation? Well, it is the examination of all public records in the chain of title. It's where you're going to look through grantor and grantee indexes, 25 years of title insurance, and it's also back to the origin of the title for abstract. Now, let me tell you something. It's going to perk y'all up real quick. We're almost, by the way, we only got 10 slides left, so we're on a roll. We're almost finished, okay? So, we're there. We're almost there. The key thing is, y'all, is that with title search, you can make very good money. Used to, you had to go to the county clerk's office, run title and all that. Guess what you can do now? You no longer have to run to title or to the courthouses now. Now, not all of them are up to date, but most of them are. But now most courts now have all their public records online. So you can charge up to $1,000, maybe more dollars to run a title search. You go and run that title search, you can send over that information to an attorney, they can draft an abstract of title, and you end up making $1,000 for just sitting behind your computer typing in some information. Not a bad day, okay? That's what a lot of title companies do. They sit behind and run searches and make money just sitting behind their desks. The chain of title is going to establish a succession of ownership interest. Again, we talked about the suit to quiet title. If there's a gap, the abstract of title is going to be the condensed history of all instruments found. Basically, what an abstract of title is, it's literally, Mr. Eugene, they give you this form and it tells you all the way back to the very beginning who owns your property and everything about that property. Gives you it's kind of like your financial, your credit report, but in regards to your property. Okay, it tells you everything. The origins of Texas land titles. Now, you do see you've got Spanish, Republic of Mexico, and the Republic or State of Texas. In Spanish, it grants, signs, and authenticated, which is going to be what's called a protocol. The extract of a grant given as a title evident is going to be a testamundo. Okay. The Republic of Mexico was settlers granted a lead of approximately 6.919 square miles, and this was the Walter Scott's lead. The Republic or State of Texas grants are going to be referred to as surveys at 640 acres, and Amos Water Survey would be an example in that. Now, Mr. Aiden, tonight I need you to know everything about the top two, okay? I need you to do a detailed analysis and write a research paper on those for me, okay?
Can I do it over the Republic of Texas as well?
No, we don't want you already know that one. We just want you to do the top two.
There is. Okay.
Okay? So, the evidence of title, of course, there are two different types. There's what's called the abstract of title, and then there's the attorney's opinion of title, okay? The abstractor, that's what you could do on the side. An abstractor compiles the abstract, and a buyer's attorney prepares an opinion of title. While if they don't have their own personal attorney, they can use title insurance, and it's the insurance policy which then indemnifies the insured against losses resulting from the defect in title. Okay, so if they don't have an attorney on staff, they can use the title insurance to cover them. Again, an abstractor compiles the abstract, which gives a condensed history of the instruments affecting a parcel of land. They conclude with a certificate, and it can be liable for negligence, but it does not pass judgment or guarantee the title. Okay, it's just here's the information. The buyer's attorney is going to prepare an opinion of title. They look at the information, they evaluate the facts, then they prepare the written opinion of title. The disadvantages, though, to this is that it does not protect against what's called undiscoverable defects, meaning that if I went through and did a search, I might have missed something. Well, if I missed something, that's pretty much on that buyer. It's not going to be on me, it's going to be on the buyer. And again, mistakes can be made, and there are no guarantees. Therefore, in that particular situation, you're pretty much screwed. Okay. Title insurance also indemnifies against unknown defects in the title and will compensate. Okay, you see the difference here? Will compensate or reimburse. It does not guarantee continuing ownership, and title commitment will state terms and conditions under which a policy would be issued after the title search and within 20 days of the contract receipt. In regards to the owner's policy, it assures the buyer that the title is as stated, subject only to the noted exceptions. Reimbursement can be also up to the purchase price, and it converts to a warrantor's policy on sale. Okay. Mortgagee's title policy also assures the lender of a valid first lien. Its reimbursement limited to the outstanding loan balance and transfers with each sale of the note. The certificate of sale policy is also to a purchaser in a court sale. The standard coverage, as well as endorsements and exclusions, are all going to be stated within the title insurance policy. Again, they're going to look at what's called a good and indefeasible title versus a marketable title. Again, the key point behind this is we want to make certain, by all means, that all of the information that is provided is true and accurate. And looky there, we've finished. Okay? So, Mr. Grossman, can you go ahead and please stop the recording?